FSN Radio. It's all about what's next. Go to financialsurvivalnetwork.com and sign up for your free weekly newsletter. You'll also get 3 free reports. The Financial Survival Network. It's all about what's next.
Welcome. You are listening to the Financial Survival Network, and so much of our survival, financial or otherwise, hinges upon the legal system that you got to be aware of what's going on here. And we've got Reid M. Hart, an attorney up in Jacksonville, Florida, my adopted home state, who's going to fill us in on an interesting case and what goes on in a grand jury, how people get indicted, and how sometimes actually justice prevails and they don't get indicted. And Reid, welcome to our show.
Hey, Kerry, appreciate you having me.
Hey, so got this case here of some football players up in Brown University. If you're not familiar with Brown, it is one of the Ivy League schools, and these football players accused of rape. And tell us exactly what happened here, Reid.
Yeah, this started back at the beginning of the year. I think the original complaint was made in February, where a female student of Providence College, actually, that was a first-year student, had submitted a complaint that 2 Brown University football players had sexually assaulted her one night after a bar. And kind of the gist of the complaint was that she was at a bar, that she had had one shot, and felt that based on the fact she had only had one shot, that she must have been drugged or something to that effect, because all she remembers is being carried out of the bar into a cab. And then the next thing she knows is she wakes up in a Brown University dorm room, in a bed in one of the dorm rooms. And that when she wakes up, she's with another male, with one male in the bed and then another male that is encouraging her to commit a sexual act on the other gentleman in the bed, and that he had a camera and took pictures and recorded at least some of it, and that the next thing she knew, she woke up that morning and got a cab back to Providence College and then made the report that night to law enforcement. And then at that point, it kind of took off from there. And I think it was actually the same week that Brown University issued a no trespassing complaint or warning for the 2 students against whom she made a complaint.
And then obviously the police get involved, right? And
right.
What happens then?
Well, yeah, law enforcement, the school acted before law enforcement really were able to conclude any type of investigation. The school, like I said, issued the no trespassing, and then in April had a hearing of sorts and made a determination that the students would be kicked out of school, or ultimately kicked out of school. And then after that, over the summer, the state attorney's office or the prosecutor brought the case to a grand jury and seeking an indictment against the 2 Brown University students. And, we'll get into, I'm assuming that how a grand jury works, but what it is there's no defense attorney. There's a judge every now and then to just rule on certain issues, but the judge does not conduct the proceedings. It's strictly done by the prosecutor. They present, the evidence that they have witnesses. And actually the members of the grand jury themselves can ask to subpoena witnesses. They have subpoena power. They can question the witnesses on their own. They can ask certain evidence on their own. And at the end of the day, in the standard, as opposed to a regular criminal case, which is beyond and to the exclusion of a reasonable doubt, the standard in the grand jury proceedings is a probable cause, which just means it would a reasonable person exercising a cautious mind believe that this individual committed the crime for which they are being charged. And they came back with these 2 Brown students and ultimately found that there was not probable cause to move forward, and therefore they did not issue the indictment.
Hey, and you've been involved in criminal law most of your career. How hard is it for a prosecutor to get an indictment from a grand jury?
It's not at all. As you can imagine, it pretty much is whether they want to or not. For the most part, you always hear the saying that they can indict a ham sandwich, which is a cliche type of phrase. But at the same time, it is rather true as far as their ability to get indictments when, on evidence that is not what some would perceive as being very strong.
Right.
So the fact that the grand jury in the case did not come back with an indictment is extremely telling about the evidence or lack thereof that they really actually had in this case, on which the school acted almost immediately in kicking these guys out of school. So, unfortunately, you're left with that scar. They're left with the scar on their record, and and they're going to have to live with that.
Yeah, and if they go and sue the school, what are their odds of winning?
I mean, their odds of winning are slim to none. They're going to show, the school is obviously going to protect themselves and say, hey, we followed procedure, presumably followed procedure in this instance, and that based on the evidence and testimony they had at the time, that they feel they acted appropriately. Any type of suit too, you're going to have to show that the school acted kind of in bad faith, or that they violated their own procedures or something of that nature, which, being Brown University, I highly doubt they necessarily violated procedures, even if it was, a situation where they jumped to conclusions.
Yeah, and these hearings that these colleges have in this situation, can you describe them?
Yeah, what it is usually is members of the student or the school, kind of the executives, come in, and essentially what you do is, and the student is not given any opportunity to have attorney or counsel present. They are typically given an advisor, a school advisor, but that person, the procedures typically make it very clear that person is not to advise them throughout the course of the hearing, that they're simply there in order to kind of let them know what the process is, what the procedures are, and what their opportunities are going to be during the hearing. But, in most instances, the school already has made a decision as far as what they're going to do moving forward, and it's typically just a formality at that point as far as going through, asking the person that filed the complaint what happened according to them. And of course, the person that filed the complaint typically does have an advisor because they are the quote-unquote victim. And so they give their side of the story, and then the accused is given an opportunity to give their side of the story. Of course, they're left in a defensive position. They don't get a chance to necessarily challenge the series of events given by the alleged victim. And that's what they're left to make a decision on. And, obviously a school being a public institution, most of the times, even though some are private, are typically going to err on the side of caution in 99% of the cases, and take disciplinary action against the student, regardless of the ultimate outcome as far as the criminal process is concerned.
Yeah. So, is this really due process here? I mean, is it really fair? I mean, I know when I was 19 or 20, the idea of actually having to represent myself, before a hearing or a court, I don't know. I don't think I would have been capable of doing it. And I can't believe these football players actually could have adequately defended themselves before this hearing either.
No, yeah, there's nothing really having to do with due process as far as those hearings are concerned. I mean, because typically law enforcement investigation hasn't even played out by the time these schools have these hearings, because they want to act so quickly. And the person hasn't had time to vet whatever evidence it is that's been alleged against them. And as far as the story, the alleged victim's story is concerned, they don't have the opportunity to necessarily know what may be out there regarding that version of events, and the opportunity to challenge it like you would get in a court system. And in this case, we see the court system process does play out, and they're ultimately exonerated. Yet now they have to go back, and they have this thing on their school record that indicates they were kicked out based on an allegation of sexual assault, which is perhaps short of killing another person, is just as, if not even in some eyes, worse. A sexual assault allegation is just as, if not worse, in the eyes of some. So they're going to have to live with that, unfortunately.
Yeah, there's just something wrong with this whole system. I mean, I've had experience with it myself, and I've seen that they just don't get a fair hearing. And obviously, the school has an interest and has to protect the students who are there. But it all brings back that Duke lacrosse case where, obviously the state was totally at fault. The DA, he made up his mind and it became a witch hunt. But Duke University went after these guys too and really didn't protect them either. And this whole academic system of hearings and probation and expulsion, there's really something drastically wrong with it, isn't there?
Yeah, there is. And one of the main issues, and you see it, like you mentioned, the Duke lacrosse case and this case and the various ones you see around the country, is that these public institutions and schools bend to public perception and public pressure, whereas the court systems, they do at times, certainly. I'm not going to be naive enough to think that they don't, but they are at least a bit more separated, especially in the grand jury situation, which is a confidential proceeding. So those grand jurors don't have that public pressure because they know their names are not going to be exposed. And that's one of the reasons they are kept secret is one, to protect the identity of the accused in the event that grand jurors do not return an indictment. And then two is to protect the grand jurors themselves, to protect against retaliation and various things like that, as well as the witnesses that testify to protect them. So they don't necessarily bend to the public perception as much, and they're able to make an honest and straight determination based on the evidence and testimony that they receive, which in this case they found was not enough to even find that there was probable cause to believe that what this alleged victim was claiming actually happened.
Yeah, and I guess all the college cares about is like covering its butt, pretty much. They
got to fill the desks in the next semester, so
Mm-hmm. And just like if there's any possibility this person might be a danger or might present a threat to the student body, get them out of there as quick as you can. And hey, they did what they were supposed to do, because on the other hand, if the person really was a threat and they injure somebody, then the school has liability, right?
Right. Yeah, and that's the headline they're worried about is previous complaint made, school board exonerated. Essentially to where people can point and say, "See, this person should have never been here to begin with," and that had you acted appropriately the first time, then this incident never would have happened. That's the headline that they're certainly looking to avoid, which you see quite often in the cases of sexual assault allegations and things of the sort, where people are just worried about making that decision to let this person go on their way and then have something happen down the road.
Yeah, so they're kind of in a no-win situation as well. You can kind of understand their position, but it's really manifestly unfair. And unless there's a smoking gun involved, how are they in a position to be the ultimate, teller, judge, jury, and executioner, effectively?
Right.
So.
Right. Yeah, and I think they kind of lose sight of the impact that it has on the lives of the individuals or the individual involved, and the fact that they're going to have to live with that the rest of their lives just so the school can save themselves a little bit of PR.
Yeah, that really is what it's about. So, you had any other interesting instances of grand juries, surprising you?
Not as much necessarily. Unfortunately, you see obviously big deal these days is all the law enforcement cases that are being brought to grand juries. And I know in the state of Florida, a law enforcement officer has not been indicted by a grand jury in over 20 years.
Really?
for the use of force, which is a shocking number. And the Florida Department of Law Enforcement has found no blame or no culpability on the part of law enforcement in that span of time either, which kind of lends to the fact that they're creating a policy through their practices of allowing these officers to use this type of force, even if it is unreasonable, because they know, hey, the Florida Department of Law Enforcement isn't going to find me responsible anyway. So it gives them that half a second when they make a split decision that they feel comfortable in being able to use that force. So that's the only other thing where really grand juries you're seeing a lot of kind of scrutiny as far as the process and things of that nature. But no, most of the time as grand juries come back and they indict just as the prosecutor was seeking, because it's a the defendant and the defense, any attorneys involved have no opportunity, no right to really challenge the evidence being put in front of them. So that's why you see so many come back with an indictment, even though the individual may ultimately get found not guilty or the charges may ultimately end up getting dropped altogether.
Here, I thought our law enforcement in Florida was just above reproach.
No, unfortunately, yeah. That's kind of the way it is that their decisions are seen as being clean across the board. And common sense would tend to side on the fact that there's at least a couple that most likely weren't. But that's the system we're left with.
Hey, one thing I wanted to ask you about, I don't know if you've read this, speed trap town, Waldo. You familiar with that situation?
Oh yes, yes, and I have unfortunately been the victim of the speed trap situation in Waldo. I travel a lot back and forth between Jacksonville and Gainesville, so I go right through Waldo. And yeah, I did see the recent story about the quota system that they had on the tickets and the citations, and the evidence that they have with emails telling officers you don't have enough tickets, make sure you get some more, and that type of thing.
So that's been going on for decades now, right?
Yes.
And
yeah, I mean, ever since I can remember.
Right. So in case you're not familiar, Waldo, a speck of a town, they're giving out thousands of tickets, and basically it's supporting a bloated town. Evidently money's missing, and they have a quota system, which I believe, correct me if I'm wrong, Reid, is illegal under Florida law to require officers to have a quota for giving out speeding tickets. The state had to have known this is going on for years, correct?
Yeah, knowing how close the state attorneys, yes, one would have to assume, based on how close these prosecutors and state attorneys work with law enforcement. I see it in the back rooms all the time. They're awfully friendly. They work with them on a constant basis. You have to know, if they didn't know, it's because it was a situation where they consciously turned the other way. Yeah, which at that point you're just as responsible as if you knew first and foremost.
How does this thing go on all these years? I mean, I've talked to people, and everybody gets nailed in this town. And there was another town that only existed to be a speed trap, and these situations go on for years and years, and the state just turns its back until finally enough people get upset, and they upset the wrong people, I think is what it is, and then finally something has to be done about it.
Yeah, I mean, it's a situation like, a lot of other instances you see where it's a matter of getting the smoking gun in the hands of the right people. Because the prosecutors and state attorney's office works so closely with law enforcement, it really isn't in their best interest to go against law enforcement on their own. Because if they are viewed as doing that, then law enforcement may not work so well with them in the future. And so they're cognizant of that relationship when they're doing things like that. So, like you said, it's just a matter of upsetting the wrong person, or as far as the public is concerned, the right person that has an opportunity to get a hold of that information and do the right thing and bring it to the attention of people that matter.
Yeah, I guess my point is that these things happen just like the academic judicial system, if that's the right word, that really are against the public interest, and they continue on for sometimes decades at a time, and nobody does anything about it. And, it just continues on until finally something happens to trigger a change, and then something gets done. And I just wonder what it's going to take with colleges before it happens. And this administration, current occupant of the Attorney General's office, has been instrumental in pushing colleges towards these, basic kangaroo courts, pushing them to prosecute these sexual assaults, even when there's not even a legal case that can be brought.
Right. Yeah, because a lot of the excuse that you hear is that, well, just because they can't prove it in a court of law doesn't mean that it didn't happen. And that's kind of their excuse for doing it and not allowing the court system to play out, because in their view, it doesn't matter. They're going to move forward based on the information they have. And if they decide it's enough in their heads, however many of them there are, with presumably little to no legal background, if it's enough in their mind and they feel that they're doing the right thing, and, the person be darned if they end up getting prosecuted in the criminal realm or not, that they're going to get tagged with this description moving forward regardless. It's a shame, quite frankly. And I think it's going to take, a congressperson's or a legislator's son or daughter being involved in one of these hearings and getting railroaded, as some have, to finally say, hey, there is something wrong with this system and it needs to be changed.
Yeah, it really is. And yeah, I mean, the grand jury system has served us for hundreds of years now, going back to England. It definitely has its weaknesses, its pitfalls, but at least it does serve as a check and can really, really protect one's rights, especially when there's a real overzealous prosecutor, and, you know,
right.
give a defendant an opportunity. I mean, most defendants never testify before grand jury. It's going to be interesting to see what happens with the grand jury in Ferguson, Missouri. You know,
right.
see what goes on there. But hey, want to thank you. Hey, just tell us where we find out more about you, Reid, and what you're doing.
Yeah, it's well, I'm employed, or I work with, practice criminal defense exclusively with the law office of John Phillips in Jacksonville, Florida. Our website is www.jaxarrest, it's JAXARREST, jaxarrest.com.
All right. And hey, we'll have a link to your site on our site, www.financialsurvivalnetwork.com. Don't forget to sign up for our newsletter. Hey, we're aggregating alternative financial news from hundreds of sites every week. So you definitely want to go check it out to find out the real news. And Reid, thanks so much for coming on. We really appreciate you taking time out from your busy day.
Hey, it's been a pleasure. Y'all have a good day.
FSN Radio. It's all about what's next.
The show's brought to you by Audible. Audible's back as a sponsor. Just go to audiblepodcast.com/FSN and you'll see they've got over 150,000 titles to choose from fiction, nonfiction, bestsellers, every category imaginable. They've got free apps. You can download and listen on your iPhone, iPad, Android, Windows Phone, every device imaginable. And unlike a streaming or rental service, with Audible, you own your book. So you know that I've been an Audible fan for years now. I've listened to over 310 books since I've had it. Last one that I listened to was called The Frackers, and I will give a hat tip to Jason Burak for that one. An incredible book about the history of fracking in America, in Texas, and how it developed in North Dakota. It's a book that you really got to check out. I'm reading one right now, or I should say listening to it, called The Sons of Wichita, about the Koch brothers and how that family developed an immense business worth God knows how much, hundreds of billions of dollars. Incredible book. There's so many great books. I love the Joseph Finder books, the Harry Bosch series by Michael Connolly, but you've got so many books to choose from that you'll have to find one. And Audible's got an incredible offer for you right now. Go to audiblepodcast.fsn to take advantage of it right now. Okay. The way it works is really simple. You get a free audiobook of your choice and a free 30-day trial membership. So check it out now. It's really great. It's easy to use. And look, if you're like me, you don't have the time to read as much as you used to. But if you're driving in the car or you're sitting out by the pool or the beach, you put on a book. It's an amazing service. I love it. You will too. Go to audiblepodcast.com/FSN. Take advantage of that free book and that free 1 month's membership now. You're going to love it. I promise you. And tell me some books that you like, that you've listened. I'll tell you some of mine. If you send me an email today to KHL@kerrylutz.com, I will give you my top 10 Audible picks. And I guarantee you're going to love them. Check it out now. audiblepodcast.com/FSN.
FSN Radio. It's all about what's next. Go to financialsurvivalnetwork.com and sign up for your free weekly newsletter. You'll also get 3 free reports. The Financial Survival Network. It's all about what's next.